Um, I'm Jed Rakoff, a federal judge, and I am absolutely pleased and privileged to be able to offer a few comments at the outset of this uh, program with its very, very distinguished group of speakers. The uh, I would have to say at the very outset that um, what Churchill said about Russia is sort of what I feel about um, uh, eyewitness identification uh, uh, evidence. It is a riddle wrapped up in a mystery inside an enigma. Um, and who would have guessed? The uh, on the one hand, it's probably uh, uh, the oldest, so one of the oldest forms of evidence. Jacques Hughes, I saw that person commit the crime with my own eyes. I know he is guilty. Uh, on the other hand, um, there is now very ample evidence that it is perhaps um, the single most important factor in wrongful convictions, especially very serious crimes like rape and murder. For example, the Innocence Project, through its use of DNA to determine that people convicted of very serious crimes are actually innocent, uh, has said that wrongful eyewitness identifications are present in no fewer than 70% of those exonerations. And what's even more mind-boggling, uh, in about a one-third of those, there were multiple identifications. People with no motive to lie who took the stand who said, yes, that's the guy, but they were wrong. Um, and finally, just to compound the difficulties, while some of these errors could have been avoided through better police practices, um, others were the results of limitations and imperfections in human perception and human memory that may be intractable. So let me give a little bit of the legal background. Even before the Innocence Project, the Supreme Court had become aware that there were too often wrongful eyewitness identification convictions. And beginning in a series of cases in 1967, Wade and Stovall and so forth, they had first attempted to deal with this by making the system more comport with adversarial requirements. So, for example, a defendant had a right to have a lawyer present at a lineup or a photo array. Um, that has some modest positive effect. Beginning in 1977, a decade later, the Supreme Court tried to do a more hands-on and more complete uh, analysis of what could be done to make this area of evidence better, notably uh, in the Manson v. Braithwaite case, but a number of cases from that period. And uh, they, of course, stated the obvious, which is that reliability is the linchpin in determining the admissibility of identification testimony. And to that end, they instructed judges first to determine whether the identification procedures, the police procedures mainly, were unnecessarily suggestive. And second, whether uh, the identification was in any event, reliable or unreliable. And they asked judges to take a look at 5 factors: the opportunity of the witness to view the uh, criminal at the time of the crime, the witness's degree of attention, the accuracy of the witness's prior description of the criminal, the level of certainty demonstrated at the confrontation, and the time between the crime and the identification procedure. Now, none of this was based on scientific research, and some of it has been cast into doubt. Other factors that we still accept, we could be much more precise about as a result of scientific research. But there are also all sorts of factors that the Supreme Court never remotely dealt with because they were unaware of these factors that later scientific research would reveal. And as a result, while the Manson test has limitations and has not been obviously as successful as one would like in preventing wrongful convictions, it did lead to some improvements, and those have continued in recent years as a result of continuing criticism and reports. For example, there are now 9 states where the person administering a lineup or a photo array has to be someone other than the person who was involved in the underlying investigation, and therefore there's much less chance of wrongful suggestiveness, even if just through body language on the part of the person administering the test. Also, in at least 11 states, it is now required that the eyewitness's initial level of confidence at a lineup or a photo array be recorded. This was implicit even in the Manson test, but it's now required in at least 11 states. But as those figures suggest, there are a great many more states where these are not requirements and where police practices continue to be overly suggestive. And I think perhaps the first panel of this program will be addressed to some of those continuing problems and what can be done about it. But as I suggested, perhaps the bigger problem, the more intractable problem, are inherent limitations on human perception and memory. These were the subject of the National Research Council report about 5 years ago. And there has been continuing research in this area, which some of the speakers will be speaking about. Now, some of these limitations are at least obvious to even a lay juror or a lay judge. For example, whether there was obstructions in the path of someone's viewing the criminal, or whether the person who's testifying has problems with their eyesight. The greatest, in my view, the greatest movie ever made about the trial system is My Cousin Vinny, and a large section of My Cousin Vinny is devoted to exposing in the courtroom just these kinds of limitations. And when they're exposed, the jury and the judge immediately understand the problems. But unfortunately, there are many more subtle problems that are not part of everyday automatic knowledge, experience, and understanding. For example, there's the tendency to fill in the gaps, to merge memories. Um, the first time you see the defendant committing the crime, you perhaps have a short view of his or her face. Maybe 6 hours later, you're shown a photo array and you're studying the faces in the photo array much more carefully than you had the opportunity to look at the defendant. And the one who seems to you to be closest to the uh, defendant you saw commit the crime has a scar above his uh, right eyebrow. Well, by the time you get to testify in court a year later or so, those memories have merged. And you honestly but erroneously believe that one of the reasons you're sure the guy in court is the guy you saw commit the crime is because he has that scar above his right eyebrow. So that's the merger effect. Another effect is the tendency to have increased confidence in one's identification over time. Now, it is the case that the initial confidence of one's identification, one of the factors that the Manson court emphasized, is often a function of personality. Some people are by nature less confident, more diffident in their opinions and their perceptions. Other people are cocksure. We call those latter people federal judges. But in all seriousness, there's a very wide range of uh, 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 how people will tend to have a degree of confidence or lack of confidence in their opinions. But what is true, nevertheless, is that over time, those opinions will grow more sure. The psychology that leads to this is, I think, still somewhat uncertain, but the fact that it happens is well established and difficult to deal with. And then, just to give one more example of many, there's the well known racial disparity effect. People of one race are much less good at discerning and remembering the fine facial features of persons of another race as compared to someone of their own race. Um, Again, there is, as I understand it, at least some debate and uncertainty over why this is so, but no debate over the fact that it is so, and it can easily lead to mistaken identifications. So then the question becomes what to do about all this. One's suggestion, and this was adopted in part by the National Research Council, was to allow foundational experts to educate the jury about some of the problems that they might not be aware of that are inherent in eyewitness identification. Um, uh, so far as I'm aware, though there will be speakers later who will address this with far more knowledge than me, this has not been used in many cases. I've seen it once in my own court, and also where it does occur, there are frequently competing experts on both sides, with the result they tend often to balance out and not have as educative effect as one might hope. Um, an alternative that has been widely considered and is the law in New Jersey and a number of other states to a lesser extent are uh, jury instructions, either at the time of the identification or as part of the final instructions to the jury, educating them to some of these problems. The very preliminary studies that have been done with mock juries on this are disappointing in the sense that the jurors tend to view these instructions not simply as educating them, but rather as a subliminal message that the judge doesn't believe the eyewitness. And so there's an overkill effect with some of these instructions. But I emphasize that's very preliminary research, and a lot needs to be done. Uh, I would emphasize the fact that juries are really an irrelevancy in the great majority of criminal cases. Well over 95% of all criminal cases, state and federal, are resolved through plea bargains. So, in some ways, the person or persons who most need to be educated about the limitations of eyewitness identification are the police and the prosecutors. I think there has been considerable progress in educating police. My experience so far, at least in my own court, is very little progress in educating prosecutors as to the limitations of eyewitness identification. Um, this is probably not something judges can order, but it is probably something they can strongly support, and perhaps a new administration would be very open to such an approach. Now, on the hopeful side, their technology has come to our um, rescue in many cases now through videotaping. And while videotaping has its own problems here and there, um, it's a great improvement over eyewitness identification in a great many cases. Unfortunately, however, there are all sorts of cases where there's no opportunity for videotaping and it's not really going to be part of the mix. Just to give an obvious example, spousal abuse cases very rarely involve a videotape of the actual beating. Um, Sometimes there are hospital records that are suggestive. The testimony, I've had a bunch of these cases, the testimony uh, tends to be problematic because, among other things, the spouse will often recant her testimony. Um, so this problem is going to be with us for many decades to come. Um, and what there really needs to be is a lot of fresh thinking. And I am very confident that the very distinguished speakers in this program will provide us with uh, fresh thinking that will be very helpful to judges, juries, prosecutors, police, and defendants. Thank you so much.